So today's topic is mistake. First of all, there are three main types of mistake that we'd like to discuss today. First is common mistake, mutual mistake, and unilateral mistake. Common mistake is where the mistake is common to both parties. So both parties make a mistake and the parties reached a valid agreement, but they want to cancel the contract because there is a mistake as to the terms or subject. And what happens in this case, then the court may nullify the consent of the parties and set aside the contract, but there are some conditions. For example, the mistake must be one which is fundamental to the decision of the parties to enter into the agreement. It's a fundamental mistake, or the party wants to rely on the common mistake must have reasonable grounds. So there has to be either a fundamental mistake or the party has to have some reasonable grounds. This is a very important case for this common mistake. Here in Bell and Lever Brothers, the defendants, Bell and Snelling, entered into a contract with the claimants under which they agreed to serve for 5 years as chairman and vice chairman of a subsidiary company of the claimants. One of the terms of their service agreements was that they must not make any private profit for themselves by doing business on their own account. And the claimants then decided to terminate the contract with the defense by paying Bell 30K and Snelling 20K. However, when they discovered the breach, they sought to recover the money. House of Lords held that claimants could not recover the money paid because mistake was not sufficiently fundamental to avoid the contract. The test established by the majority of the House of Lords is that common mistake must relate to something which both parties must necessarily have accepted in their minds as an essential element of the subject matter. As you can see, the threshold for satisfying this fundamental mistake is very high. Even breach of contract may not be enough. So it has to be taken into consideration that this is a very narrow scope of application, the fundamental mistake, and most of the cases may not satisfy it. So if you have a problem question about common mistake, you should have alternative grounds. So if there is a mistake made in the agreement, you should say that yes, common mistake on the basis of having a fundamental mistake made in the agreement can be one ground, but there are some alternative interpretation that could be applied to, because this fundamental mistake ground is very narrow in its scope. So the principle is that a mistake must be fundamental in order to entitle a party to set aside a contract. What is a mutual mistake? This is a mistake by both parties. With mutual mistake, the contracting parties are at cross purposes, but each believe that the other party are in agreement. There is a misunderstanding as to the terms of the contract or the subject matter. The case that shows this ground of mistake is Smith versus Utes. A buyer purchased a quantity of oats from seller in the belief that they were old oats. However, the oats were in fact new and consequently unsuitable for the buyer's proposed use. When the buyer discovered his mistake, he refused to accept the oats. As a result, the seller sued for the price. On the other hand, the buyer brought an action for mistake and misrepresentation. Both actions failed. The term old was not in the contract. Despite of the seller knowing that the buyer needed old oats to feed his horses, this was a mistake as to the motive and not intention. Therefore, the seller did nothing to mispresent or deceive the buyer. Again, this case shows how narrow it is, the scope of application of a mistake, and it will not succeed unless it is truly a mistake by both parties as to the understanding of the essence of the contract. Unilateral mistake is also another possible scenario that could happen. This is where one contracting party is under a mistake as to the terms of the contract, and the other contracting party knows or ought to have known that mistake, proceeds with the contract and takes advantage of the mistaken party. Interventional estates is the example of that. Here, the claimants wrote to the defendants, inviting them to agree that the current market rental value should be 65K, and the defendants accepted. When claimants received defendants' written acceptance, they immediately contacted the defendants to inform that they had meant to propose 226K and not 65. Defendants refused to agree to this new figure and insisted that the contract had to be at 65K value. Claimants failed to negative the existence of the apparent agreement to the parties to treat 65 as the current market rental value for the purposes of the lease, and to deprive the defendants of their right to defend this action on the basis of such agreement. Therefore, defendants were successful. So as you can see, in most of the cases, unless there are some strong arguments made, mistake will not succeed. In this case as well, when they made a mistake as to the rental value, they was not successful, and the claimants had to have the 65K, the original value for the contract, rather than the new value, because that was the one that was accepted, and once the contract is accepted, then there is a binding contract and they cannot change it. Mistake as to the identity or attributes of the other contracting party. Mistakes as to the identity are generally induced by fraud, in that one of the parties is claiming to be someone who they are not. Thus, there is an overlap with misrepresentation. And the problem questions, I've seen this kind of mistake as to the identity more commonly coming up in other grounds. So make sure that you are aware of the possible cases about this, and you should learn the cases about the mistake as to the identity, and then know how to apply it to a common problem question scenario. Ingram versus Lissell is a classic case on mistake as to the identity. Here, 3 elderly sisters advertised their car for sale. A scammer who called himself Hutchinson agreed to buy the car by payment of the check. However, the ladies refused to go ahead with the sale as they wanted cash. In order to persuade them that he was a reputable person, he gave his name as Mr. Hutchinson and provided them with his address. In order to verify his statement, one of the sisters went to the post office, confirmed his address, and accepted the check. But the check was dishonored. In the meantime, the car was sold to innocent third party. When the car is sold to innocent third party, it is a classic scenario of a problem question about this mistake as to the identity. And then you need to discuss if the original owner can recover the property when the innocent third party has already bought it. The Court of Appeal held that the woman should succeed in the recovery of their car. Their response to the check and their insistence on verifying the address demonstrated the identity of the other person was very important. So they could set aside the contract on the basis of a mistake. I suggest that you read our notes on mistake in full. We have all the main cases in our notes. And the other resources that we suggest you have a look is at this link for our quizzes, flashcards. We have tutorial videos as well. We have example essays and case summaries. The notes contain the case summaries, but if you go to the actual case summaries that we have on the website, that's a longer version. So the notes have a shorter version of cases, and on the website we post longer summaries in case you need to do some detailed research. So at the end of this tutorial, I'd like to let you know about our services, how we can help you with your assessments. We have a team of content creators that provide simple study materials for you to make sure that you get highest grades in the simplest way possible. 90% of our regular users could get a first class this year, as they have told us recently. If you combine our study materials with tutoring, that is the best chances, that will give you the best chances for you to get a high grade first class in the simplest way possible. If our resources are not enough, or if you cannot find what you're looking for on our website, you should definitely have a look at our tutoring services. That is a personalized, tailored support for law students, where you can be on a Zoom meeting with one of our tutors, and the tutor will guide you through in detail with your assessments, with your coursework. We even help with mooting and dissertation. If you want to be our next student to get a first class law degree, please join us now. Thank you very much.